And Danielle. Okay, so welcome everybody. Wait. Yes, welcome everybody. I am Mike Madison. I am a law professor at the University of Pittsburgh, where I run something called the Future Law Project. I am your host and presenter on this series called The Future of Law, the Future of Technology in Law and Governance. Nope, The Future of Law. Yeah, I got to make sure I get the title of my own series correct. The Future of Law and Technology and Governance, a series of scholarly seminars hosted and facilitated by the Center for Governance and Markets at the University of Pittsburgh Graduate School of Public and International Affairs. I'm going to introduce our speaker today and then turn the microphone over to him. And then in about 30 minutes, we'll take a break and I will moderate a Q&A until the top of the hour. Our speaker today is Michael Sinha, who comes to us as a professor of law at St. Louis University in St. Louis, Missouri. So welcome to Michael. His title is Data Privacy and Security Concerns After Roe v. Wade. And before turning it over to him, I do want to acknowledge and thank my Pitt colleague, Dr. Lisa Parker, who is faculty in the School of Public Health and the director of the University of Pittsburgh Center for Bioethics and Health Law. Lisa has been collaborating with me on producing several of these seminars this year, and it is a great pleasure to be able to do that and to welcome her today as well. So thank you to Lisa. With that, I'm going to mute myself. Welcome, Michael, and over to you.
Thank you. It's a pleasure to be invited to what sounds like a really interesting series. I saw some future talks that I may be joining. So I'll start out by acknowledging that Roe v. Wade was decided 50 years ago this week. So it's somewhat of a bittersweet anniversary. But Roe v. Wade was decided by the Supreme Court in 1973. And it noted that the right to privacy founded in the 14th Amendment's concept of personal liberty and restrictions upon state action is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. And the court noted that the detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. So they spent a lot of time going through the data, the evidence suggesting that limiting access to abortion care cause significant health problems, public health problems. Flash forward to last summer, June 24th, the decision in Dobbs v. Jackson Women's Health Organization, where the court there noted that it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. This is what the Constitution and the rule of law demand. And so we have overturning of nearly 50 years, now 50 years of precedent set by Roe v. Wade. And so I'm here to really try to digest and understand what it means to return the issue of abortion to the people's elected representatives, as the Dobbs decision was noted, and what the implications are for data privacy more broadly, especially as states pass more and more onerous laws restricting or even banning abortion care. So the first thing to note is that now that we have overturned a constitutional right to abortion care, we now have a wide array of states that have very different policies in place. And so we have some states that have actually expanded access to abortion care well beyond that which was set as somewhat of a constitutional baseline in Roe v. Wade. So we have Washington, Oregon, California, Minnesota, Illinois, and then several states in the New England area, New York, Vermont, Connecticut, New Jersey, and then even Hawaii. But on the flip side, we have states that are making abortion access illegal in many different ways. So we have Idaho, South Dakota, the state of Missouri, where I am, Oklahoma, Texas, Arkansas, Louisiana, Alabama, Mississippi, Tennessee, Kentucky. And this list is evolving. This map is constantly changing because we're seeing states taking action very quickly and very dramatically in some ways. So some states are going above and beyond to protect access, whereas others are going above and beyond to restrict and criminalize access to information. And so there is another wrinkle to consider, and I'm not going to talk about it as extensively here, but it's possible that the Dobbs decision opens the floodgates to other substantive due process precedents. So Justice Thomas, in his concurrence, notes that he wanted to revisit cases like Griswold that highlighted the right of married persons to obtain contraceptives, the Lawrence decision, the right to engage in private consensual sexual acts, the Obergefell decision, the right to same-sex marriage. So Dobbs and abortion care it may not be the only thing on the chopping block in terms of substantive due process rights of individuals. So that's something to keep in mind. But one of the things that I started thinking about and seeing news reports really highlighting, what does the world of data privacy look like after the Dobbs decision? Where are we going? What are the things we need to be aware of and concerned about? And so it's important to note that health privacy has been a real issue that Congress has taken up substantially over the years. So there are 20, 25 bills that have been passed in the last 50 or so years that really focus on privacy and touch on health privacy. Some of the more major ones we've seen recently: the Health Insurance Portability and Accountability Act, HIPAA, the Health Information Technology for Economic and Clinical Health Act, known as HITECH, and then somewhat more recently, the Genetic Information Non-Discrimination Act, or GINA. But each of these bills, the most recent of these bills was passed in 2009. And so really what we're thinking about here is a somewhat outdated framework for health privacy. Because a lot has changed in terms of technology and access to healthcare information since those last few laws were passed. So we'll start with HIPAA because it's the one most people discuss. HIPAA was passed in 1996, right? So quite some time ago. We're approaching 30 years since HIPAA was passed. And by definition, HIPAA only applies to what are known as covered entities. So these include health plans, healthcare clearinghouses, and there's a separate definition for that I won't get into, and healthcare providers. Importantly, and I think importantly for what we're talking about today, HIPAA does not cover non-healthcare entities, so anything that's not defined upon. And it also does not cover individuals sharing their own health data. And I think this does become important in the social media era. So the question is HIPAA a good shield? Does HIPAA, even though it was developed in 1996, really protect our health information? A lot of people think it does, right? We've seen politicians, even politicians out there saying, you know, I'm invoking my HIPAA right to decline to say whether or not I received the COVID-19 vaccine, right? So we know this is not an appropriate use of HIPAA at all. This is not what HIPAA is designed to do, but HIPAA isn't really a great shield, especially in the context of laws that are starting to criminalize abortion. So built into HIPAA is a fairly broad exception for giving information to law enforcement officials. And as it notes in the statute, it's as required by law. So if a state law requires access to health information, requires that healthcare information be given to law enforcement officials, then it's going to be given. We already have precedents for this, right? So in cases that relate to child abuse and neglect, we do see criminal charges, and often that does require access to healthcare records. Could these laws be extended to protect unborn fetuses? Could the child abuse and neglect standards be extended to unborn fetuses? It's hard to say, but we're seeing states redefining medical concepts, right? So concepts that we've understood for generations, terms that we've used consistently in the medical profession for years, for decades, are being redefined by state legislators. And then the question is, could criminal charges against physicians or facilities fall, right? What about liability of that emergency room physician, liability of that hospital or that institution? And so a colleague of mine wrote an article in JAMA about a year ago and weighed in on this and said that she did not believe HIPAA would protect patients' privacy in the face of virtually any legal proceeding. This is civil or criminal, especially if warrants, discovery requests, subpoenas, and law enforcement are involved. So this very broad exception is likely not to protect patients' privacy, even if those records are intended to be confidential. Then we get to thinking about access to telemedicine abortion, right? So demand for telemedicine abortion services and then self-use of medication abortion has increased dramatically, especially after the Dobbs decision, especially in states that are hostile to abortion care. Questions about whether or not crossing state lines or ordering online from out of state could be possible. There are companies now, Just the Pill, Jane, Abortion on Demand, and they provide abortion medication, and they will ship. They will often not ship out of state to a state like Texas, for instance, but they may allow pickup or shipment to family or friends in a safer state. So access to these services can certainly be tracked. Data regarding access to certain websites or payment to certain facilities, access to tracking records from FedEx or UPS, right? These things could all be potentially tracked and triangulated. Thinking about reproductive technology, because we know that in vitro fertilization is not always successful, and potentially, depending on the definition again that state legislators choose, miscarriages and other failed pregnancies that arise from IVF could result in criminal charges. Is this what the state legislators anticipated? Maybe not, maybe so, right? But we also have to think about the fact that there are matching agencies, procurement agencies that are involved in this process of identifying potentially donors, purchase products like embryos. Those entities are not likely to be covered by HIPAA. And perhaps those companies could be compelled to release names of those who have obtained products or services from those companies. So then the question is, HIPAA is not a great shield, and Congress is seeking to protect patients in other ways. And I just have to raise the question as to whether or not they're going far enough to do so. And so the Women's Health Protection Act was passed in the House twice in the last year. The bill would create a new federal protection for providers to provide and patients to access abortion care. And those protections would extend nationwide, and they would include even the states that have already moved to ban abortion. So a federal right to abortion care. The other thing I've written about with a law student of mine who's now working for the National Healthcare Public Health Program in DC, NHealth, we focused on a bill known as the EACH Act. This was equal access to abortion coverage in health insurance, right? And so this would ensure federal coverage for abortion, and that would include through Medicare, Medicaid, other government providers. We did write this before the Dobbs decision came out. But ultimately, what this does is rather than simply repealing the Hyde Amendment, which has historically limited federal payment for abortion care since 1976, but it would also ensure that federal payers will cover abortion services. And so this can potentially address systemic racism and health inequities that limit abortion access and coverage to women of color. So in addition to a federal right to abortion access, I think we also need to ensure coverage to alleviate and eliminate disparities in healthcare. But this talk is about data privacy and private health information. So a big concern that I have is what happens when users choose to share their own private health information. What happens if somebody voluntarily talks about their pregnancy experience online or uses applications for which data are not necessarily going to be private? So social media, the Center for Plain Language points out that most social media platforms have a privacy policy, but consumers are unlikely to read them or understand them, and they really provide no protection whatsoever. Thinking about Facebook, Instagram, and the parent company Meta, their bet is that most users have accepted a specific bargain, and that is that they're pricing in a privacy trade-off for social connection, fun, and business, right? So engaging in social media necessarily requires a privacy trade-off that we relinquish some degree of privacy in order to benefit from these platforms. And the Center for Plain Language, again, somewhat cynically, but perhaps accurately, if we think about it, notes that it seems unlikely that a business would give its consumers this very plain message. By reading this policy, you agree to let us keep track of you, your emails and photos, where you go, your devices, the internet providers you use, and possibly the same information for everyone in your social network. And if we decide we want more information, we will let you know in some way, maybe, before we start tracking that figure, right? So think about all the permissions that we just instinctively check when we download a new application. Permission to access the camera, the microphone, our photos, the data on our phone, our contacts, right? We're giving all of this up just to download and access an application. And we don't necessarily pay attention to what those things are. Sometimes they'll find ways to turn on their own. I honestly have to go back into my settings and turn back off certain settings like access to my microphone for Facebook. When we think about why we're getting targeted ads on Facebook and Twitter and some of these places based on something we might have said in a conversation to someone, you know, I think the technology has advanced to the point that it can listen and process conversations. What about cell phones, right? Tech companies, Verizon, AT&T, they're likely going to be limited in challenging court orders for user data. They're likely not to really have an interest in trying to challenge these court orders. They're likely to just hand that information right over. Thinking about encrypted messaging, so Apple's iMessage, WhatsApp, Signal, these are encrypted messaging. And so this makes it harder, but not impossible for law enforcement officers to get access to message. So encrypted meaning that only the sender and the recipient can see the message in its intended form, but that any path along the way, it's encrypted and illegible. But then the question is, what about a lot of apps that we use that are unencrypted, right? So Facebook Messenger is unencrypted. And in Nebraska last August, a 41-year-old woman faced felony charges for allegedly helping her teenage daughter illegally abort a pregnancy. So in Nebraska, police sent a warrant to Facebook requesting private messages. And those private messages showed that the pregnancy was aborted and not miscarried, as the two had claimed earlier. The messages actually showed that the mother was coaching her 17-year-old daughter on how to take the abortion pills. And interestingly, Meta, again, the parent company of Facebook, argued that the warrants made no mention of investigation into illegal abortion, but they also did not say whether they would handle the warrants differently had they actually known what the purpose was, right? So again, if police are sending warrants or requesting information from companies, I don't see a whole lot of rationale for those companies to refuse or to fight against these warrants. This is not new. It's important to note this is something that has been evolving over the past decade. In 2015, a woman named Purvi Patel was convicted in Indiana on the basis of text messages to a friend about taking abortion pills late in a pregnancy. In 2017, Latrice Fisher was charged with second-degree murder in Mississippi after a stillbirth at home. And federal officials, or state officials, I believe in this case in Mississippi, obtained internet search history. And then she admitted to conducting internet searches, including how to induce a miscarriage and how to buy pregnancy terminating medicine like mifepristone and ketoprofen. The other thing to think about are there are all kinds of reproductive smartphone apps. And soon after the Dobbs decision, even as the Dobbs decision was pending, because as we know, there was a leaked draft that certainly gave us a sense of where the court was going. A New York Times article said, oh, you've got to uninstall all of these smartphone apps that help with reproductive health. Others counter and say, you know, they're going to triangulate and find that information anyway. But there's certainly ways to track whether someone downloads or uses certain applications, right? You can track the Google and Apple Store activity, and you can actually track the use of applications. So period tracking apps, Flow, Natural Cycles, Orca, fertility tracking. So using urine dipsticks and uploading hormone levels to an app to try to track ovulation and optimal timing for fertility. And then there's another app called Fertilicon. And so there's an app for men and an app for women, and these offer reassuring statements. But potentially, the app is going to track what you click, right? Maybe you click something that says what to do in the first trimester, but you never click the second trimester articles, right? What does that tell you about whether or not someone might have sought out abortion services? And then something I thought even more about, a reporter came to me and showed me a really fascinating article that got me thinking about access to healthcare data, right? So when HIPAA was passed in 1996, we didn't have patient portal. We couldn't log on to any database and access our own healthcare records. All healthcare data at that time lived within the four walls of healthcare institutions. And these were the covered entities, so our health data was relatively protected at the time. But now we can access our own health data from anywhere, even in the palm of our hands, right? And so this recent study found that JSON files or JavaScript object notation files reveal how data are shared between web servers and web apps. And oftentimes we'll see information transferring from healthcare websites to Facebook's ad library, right? So information that is extracted, if you're viewing your patient portal, could be pulled into Facebook's ad library in a way that you might see advertisements on Facebook or elsewhere relating to health conditions that you may have or lab values that may be abnormal in your chart. That's concerning, right? And thinking about it in the setting of abortion, a positive pregnancy test, a prescription for mifepristone or misoprostol, right? And so these third-party marketing tools are pretty commonplace. And so what that means is that they absolutely can be used to track vulnerable patient journeys across platforms as they browse online. So patient portals, I think, are increasingly concerning and need broader protection from the federal government. What about tracking and geodata, right? So we know that our phone tracks our GPS pretty much all the time, even if it's turned off or powered off. Google did note that it would delete entries to location data when people visited sensitive places, such as a Planned Parenthood or another facility. But they declined to say whether other detailed geodata, such as GPS coordinates and routing info, et cetera, right? So if you use Google Maps to map your way to a facility, is that going to be deleted, or is that going to be out there in the world? There was a data collection company known as SafeGraph, and reportedly they were selling location data for more than 600 Planned Parenthood clinics for as little as $160. And so these data included where people traveled from, how long they stayed, where they traveled afterward, right? And so online advocacy and criticism forced the company to stop doing this, but they're making this data available and they're selling this data. So either it's public and visible like this, or it's somewhere in the dark web, but the data are still available for sale. And this is relevant in the context of what has increasingly been known as bounty hunting. So some state anti-abortion laws, like in Texas, actually allow private citizens to police pregnant persons for a reward. And so we already have seen protesters with signs in front of abortion clinics. We've seen violence against abortion providers. We have seen murders of physicians who provide abortion, right? Those same anti-abortion vigilantes can collect and provide or sell data to law enforcement. Maybe they track location data, text messages, search engine or browser history, right? License plate readers, geofences that collect data when a phone is in a particular location. All this information could be provided to law enforcement officers by vigilantes or bounty hunters seeking a reward for trying to out or identify people who are seeking access to these services. And then thinking about more benign things like online shopping, right? So if we shop on Amazon or Target or Walmart, a lot of that data is sold or shared with third parties, right? We've seen that viewing certain items can trigger promotional advertising on other pages. I don't know how many of you have ever been on Amazon, looked at an item, thought maybe I could use this, maybe I could buy this, and then jumped over to a different website. And there, right in the corner, is the ad for that exact item that you were just looking at, right? There was a viral TikTok video of a woman claiming that Amazon was actually asking for personal information before purchasing pregnancy tests. So think about that, right? Purchase of pregnancy tests can be a litmus test for whether or not someone is attempting to become pregnant, is pregnant, and that can put a red flag for individuals who are trying to identify who may be at risk of seeking out abortion. The other thing to keep in mind is that the purchase of other items and non-pregnancy related items can actually be predictive of whether someone is pregnant. So Target had a pretty robust marketing scheme in which their system was about 80% accurate, even if no pregnancy items were purchased, right? So the story here was that a father went into Target with a flyer that he had received in the mail. It was mailed to his daughter, and it was advertising infant and baby supplies. And he said, "Why are you sending this to her? She's not pregnant. There's no issue here." it turns out he came back with his tail between his legs a few days later and said, actually, you know what, she is pregnant. And I just didn't know it, right? But Target knew it. Target figured this out. And what about payment data, right? So medical and billing records, separate from the protection of medical data, could be released. Patronage of a pharmacy that sells only abortion pills, a charge at an out-of-state Planned Parenthood for an amount that's much higher than usual spending. Tracking what is being purchased on flexible spending account debit cards. And then thinking about banks and the protection of privacy on purchases made through checks or debit cards that are attached to banks, versus a lot of the online payment systems, our Apple Pay, PayPal, Venmo, Cash App, that essentially all say in their user agreements, they will turn documents over via warrant or subpoena, right? So if you're paying anything that you want to keep confidential through any of these apps, it sure sounds like that data can become available through warrant or subpoena. And even cryptocurrency may still leave somewhat of a paper trail. So that's not an impermeable payment method either. So really, cash is still king if we think about trying to pay for services in a way that prevents tracking, right? But again, this goes back to who has the access to the resources to pay for services, right? Not everyone has that amount of cash to be able to purchase things out of pocket. So what happens next, right? So this talk certainly generates more questions than answers. And I think a lot of the implications here remain theoretical and unknown, right? So I am speculating, I am hypothesizing, I am theorizing as to whether or not some of these things could happen. But I think the key point here is that the corporatization of data and the absence of adequate data privacy protections could make seemingly private data available to law enforcement officers in anti-abortion states. So this is something we need to pay attention to. And more broadly, I think it's become clear over the last few decades that we need broad data privacy reform and not just health data privacy reform. Because at this point, the two cannot be separated. Privacy protections need to be designed to meet the technologies people are using, right? Smartphone technologies, applications, that sort of thing. And I think there are new protections that may be needed in response to current digital platforms that may aggregate your data and grant access to third parties. So with that, I will stop and look forward to our discussion. Thank you.
Hey, fantastic, Michael. Thank you so much. That's quite a broad review of a lot of different things going on. I have questions, but let me lean back and invite others on the call to raise their hands in Zoom fashion or otherwise, and we'll open the floor. Come on, this must have stimulated some thoughts among some of you. Lisa, please.
Sure. So it seems as though, kind of as usual, there are two approaches. One is to have more disclosure and transparency about all the threats that there are to the privacy of those who are seeking abortion, and so that they can take steps to protect themselves. But then there's actually protecting themselves, which seems, in light of the technologies you were describing, frankly, next to impossible. Is that correct? And what would be possible solutions? I mean, so for example, National Institutes of Health now has certificates of confidentiality that maybe make it harder to have your research data subpoenaed. There are other realms where there are some specific protections that have been created. the likelihood of that happening seems pretty slim at the moment in most jurisdictions. Thoughts about, I mean, what's a person to do?
Yeah, so a lot of thoughts, right? So I think if we were to try to disclose all the information, that all the risks to people, we already make people sign these massive boilerplate agreements. None of those get read. People click I agree and move on. I'm not sure adding additional language to those is really going to solve the problem. It would be important to try to communicate that information more broadly, but I don't know of a good way to do so. The other point, and Professor Anya Prince at the University of Iowa actually tried this experiment. She studies data privacy and law, and she decided she actually was pregnant and wanted to see if she could hide it from all of the data privacy sources, right? And so that meant leaving her phone at home when going to visits at her doctor. That meant searching using encrypted hidden web browsers. That meant, doing just about anything she could, paying with cash. And there was an Atlantic article she wrote sort of tracking this experience. And she said that she managed for a while, but she actually miscarried. And right about at that point, she started getting all the ads. So, I mean, tremendously sad, but she's pointing out that even for someone who pays attention and really tries to understand the depths of data privacy, she tried and failed to hide her information, right? So what is there to do? I mean, I think we see models in Europe. So the GDPR, the General Data Privacy Regulations, I think the global data privacy regulations in Europe potentially have a model. Would companies, would other stakeholders in the US agree to those restrictions? It's hard to say, right? Because we know that the profitability of some major tech companies, Facebook, Google, et cetera, depend on advertising revenue. And if they can no longer collect valuable information for advertisers, that revenue may be lost.
Could I quickly ask a follow-up on that?
Yeah, go ahead.
Do we actually know that they lose a lot of revenue? I mean, if one source offers targeted data for targeted advertising, then all the money is going to go there. But if we actually made it so that you had to go back and treat the internet like a newspaper and buy an ad, would there, I mean, it would be revolutionary, but that's really what seems to me would be necessary. That's probably beyond the scope of your talk today. And I know that Daniel wants to come in, so I apologize.
Yeah. A good thought. What is a better model? I'm honestly not sure.
Okay, why don't we go to Danielle and then Anjali?
So there is just following up before I ask I make my comment on Lisa's point. I haven't seen what the models are, and because of how successful Google and Facebook and all these online even search engine. I mean, you can imagine that 85% of all the accesses to websites are Google searches. And so they have billions and billions. And of course, they're not going to give that up if they're not forced to, right? So I'm sure that it's more profitable for them to mine this data than not. A while ago, I had a startup that I was looking into, and before I started looking into the privacy issue and how egregious the exploitation is, I wanted to exploit the privacy data. And so I started trying to figure out what these models are, and I couldn't after a couple of months of trying to figure out how profitable and how can you do that, right? Is anybody willing to share their model? Nobody was willing to share their model. But you know, about figuring out, everybody just clicks accept, right? There is a site that I was trying to rack my brain. Somebody told me about it 2 years ago that classifies that you can type the name of the app or the, and then it tells you with examples what things are going to be taken from you. So the problem, I think, is first education. Even if somebody says they're going to take your photos, I may say, what are they going to do with my photos, right? I don't know. And I may also say, well, I'm very thrifty, and so I won't buy anything, even if they send me ads, right? So I know because I'm above average, and we are all above average, right? And so there is this this misconception of what is really privacy, and there is, you know, sometimes there are some examples that are so convoluted that people say, well, this is way too much. So if this is what I'm worried about, I'm not worried about this, right? So there is a problem, I think, in educating people, even tech savvy people, of what is it that could happen, and present scenarios, right? And then say you have to invest in this in order to preserve that, right? So most people, if you ask them, do you want democracy or not? I don't really care, right? Because it doesn't affect me personally. But there is education saying, look, democratic solutions are better for the world and better for society. And this is what I think the education has to go, so that we can preserve that and then put pressure on these companies to say, look, or, you know, put pressure, financial pressure, right? So it's not only political pressure, because they have lots of money to pay for marketing to counter any kind of political pressure. So I don't know if that you can comment on that.
Yeah, you know, it's really interesting. I do think that people may not think about, oh, what about pictures, right? Why should I care if Facebook wants to access my photo library? You know, I've noticed that when I take a photo on my phone, if you pop up the options below that photo, it actually, there's AI that starts to label your photos as certain things. And so I took a picture of my puppy, and it tells me, like, the AI can tell me what type of dog I have. It doesn't just say dog, it says pug. It knows. And so, I mean, it's pretty impressive technology. And so if you imagine these companies using similar technology and applying it to your photos, it can learn quite a bit. There's a new app that I found out about that younger people are using called Be Real. And apparently what happens is it sends someone an alert, and they're supposed to just take a picture wherever they are. So I have a student who says, you know, oh, I'm studying in the law library, and I'm supposed to just reach up and take a picture because my phone told me to do it. And so they're collecting a lot of information about where people are. They actually can track which floor and which room in the law school building the student is in. I mean, if photos were not valuable, then I don't think apps like that would exist.
So I'm waiting for Anjali, who is possibly preparing a question that she's going to send to me in the chat, but oh, wait, there we go. It pops up. I don't know, Michael, if you can see Anjali. I'll read it out so that we get it into the recording. So Anjali Vats says, to your point, Michael, and along the lines of Danielle's question, I'm here in the UK, where she is, where you have to hit the opt-in button for all cookies, but the strategy they've created seems to raise questions about bandwidth. Some of the companies ask you to check every option, so do you or don't you opt in? I'm curious, this is Anjali, what do you think about these attentional issues that amplify the health privacy issues that you so clearly show are proliferating rapidly, even if we can get these companies to move?
Yeah, and I'm seeing increasingly pop-ups when I go to websites now and it says, do you want to accept all cookies? And I always click no and reject as many cookies as I possibly can, right? Relatively recently it starts to show this, but if there are so many of them and we just start to become inundated, it's like, well, now what? Do we just give up and no longer browse the internet because we know that we're being tracked on every single page we access? That's not a feasible solution either, but I think there could be limits on the type of information that is collected, and that there could be potentially bars on certain sites, like patient portals, where they say no data can be collected by anyone when you're browsing certain websites, right? So, and I just want to say hello to Anjali as well. I participated in her race and IP conference a year or two ago. And I see Alice Thomas has a question here. Would a pregnancy carve out the comprehensive data statutes like GDPR or California's data protection statute work effectively? I think so. It's really hard to say, but it's interesting to see in other disciplines, in other areas where state laws in certain states, and especially a state like California, which has such a tremendous GDP on its own, independent of the rest of the United States, right? We know that if California were to become its own country, it would be a rather large country if we classified it in terms of GDP. So it does have a substantial influence on the way we interact, right? So if you look at products that are produced, kitchen products and other types of electronics, they often have a warning or a statement that they're in compliance with California state law. And so I do think there is a potential for that. But I think a much stronger protection would be something that is federal, that comes from the US government, and that is broader than just pregnancy, right? Because I think this issue is beyond pregnancy. And I think as the decision in Dobbs shows, much more could be on the chopping block. And I think that's tremendously exciting.
So we're coming close to the hour, and I want to ask us a question from a different point of view. So we've been talking about business imperatives. We've been talking about the sort of the relentless creep and scope of technology development and applications, talking about disclosure and the ubiquity of terms of use and cookies and all these kinds of things that people just, if they've got the time, they'll click through. If they've got the patience, they'll be more careful. But my question is a little different because it comes at this from a sort of a concepts of privacy baseline, meaning that for decades, intuitively and via the legal system, we've constructed a set of concepts around privacy, or ideas of privacy, that are grounded very specifically in ideas of physical space, right? Intimate privacy equals the bedroom. Familial privacy equals the home. Where you are, literally physically where you are, has an enormous influence on how we think about the scope of your privacy interest. And that is partly because of historical connections between what happens in those spaces and what we think we're entitled to do. But it also has to do with the degree to which the government, the police, anybody else can get access, right? So it's really hard for the police or the government to get into the bedroom, physically speaking, or into the house or your castle, right? Workplace is different. The street is very different. The car, of course, or the bus or the train are very different, right? What's interesting now, and what we're seeing through your explanation, is how it is remarkably simple to construct an understanding, model an understanding of what's going on in intimate privacy spaces like the bedroom via remote access, right? And the legal case that brings this home is not a health privacy case. It's the Kelo case involving thermal imaging, right? The police set up a thermal imaging technology to decide whether somebody is growing marijuana plants in their house. Like, you don't have to break down the door, just set up a machine to detect the heat lamps, right? Okay, so that, we don't need to get into the details of that, but it's so interesting that we have not really begun the process of updating our sort of cognitive models, our social models of what privacy is in social life, given all these changes to business technology and so forth that we've now been wrestling with. We still walk around with this intuition that what happens in my bedroom belongs in my bedroom and doesn't belong to anybody else. Nonetheless, most of us who have smartphones, which is most people, have those smartphones on their bedside all night long. Well, what do you think is going to happen? But we just don't have the apparatus conceptually. And so I just wanted to put that out there because I think that people who wrestle with health privacy or data privacy questions don't spend enough time operating at that conceptual level. We spend too much time debating things like the GDPR and disclosure and transparency and what's the security model for who can access data in certain questions. So I guess there is a comment in this, and there's a question, which is, what do you think? I mean, is this part of your thought process and research protocols, like baking in at the conceptual level as well as at the what we might call the legal application level?
Yeah, it's a really good question. I'll be honest, this is my first real foray into data privacy research. And so I haven't thought about the broader systemic issues as in depth, but I'll be honest, yes, I think your framing is exactly correct. When we talk about the four walls of the home and the idea that there is privacy within our home, we now have technology that accesses and invades that privacy on a regular basis, right? Our phones listen, our phones take pictures, our phones can record video. We're giving these applications access to all of that. Commercial transactions, bank transactions, stock purchases, all of it is happening at home now, right? And so the venue for commerce is within the four walls of people's homes. And so I do think that framing makes a lot of sense. Yeah, go ahead.
I just wanted to add to what the Michaels were talking about, that there is also the psychological component, because we're invading privacy at a distance. So it's not that we're physically going in and facing something. It's distant. It's not, it's the issue that people studied about stealing from a big corporation versus stealing a purse from an old lady, right? You feel like, I'm not going to steal from a person, right? But if it is impersonal, then it's easier to achieve. And also from our perspective, so I'm a computer scientist, right? So from our perspective, we're not teaching enough the students that, oh, you're doing this component, that's going to go into this other component and is going to invade somebody's privacy, right? So first, we're not teaching them enough. Second, that tech companies are paying them enough to forget that for $150,000, I'll invade somebody's privacy, right? Oh, and justifiably because it's in person.
Yeah. And there's something that just feels tangibly different between if someone were to come into my house and roam through every drawer and every cabinet versus that smartphone that I carry around all the time, right? That is collecting probably 10, 20, 30 times more information than someone would gather just walking through my home.
Yeah, I just want to draw attention to the chat, which is too thoughtful and rich to summarize in detail, but I read two threads in there that I think are worth just noting for the record. One is that debates about data privacy and data security are often proxies for merits debates about substantive interests of people and communities. And hard as those substantive debates are, they get strange and misdirected when they get sort of recast in terms of access to data, combinations of data, processing of data, business incentives associated with data. That's one really, really important thing. And thank you, Lisa, I think, for pointing that out. The other thread that I find interesting is that, and this goes to Danielle's observation about how and what we teach, particularly in technical fields associated with data, which is that because of the first phenomenon, because substantive debates about interest get transformed into debates about data and data access, it leads to a kind of arms race. Potentially in terms of the politics of data. Like, so do we want to corrupt the data gathering activity in order to disrupt the politics of blocking access to the substantive right? Overwhelm the phone lines or block the vigilantism enabled by the Texas legislation, which is an understandable political tactic, but it ends up corrupting data gathering and data pooling that might actually be socially valuable and productive. Right. It's not to say that all data privacy, not to say that all data access in the healthcare environment is bad. Oftentimes, it's really critical and important. Right. So how do we sort the good from the bad? And if we're enabling a kind of political use of data access policies in order to get at the merits disputes, then the whole system is at risk because it becomes much more difficult to detect when we're doing good data gathering and analysis or good data pooling and when it is corrupting and privacy invading. I know that's a little bit of a speech on my part. Apologies for that. Michael, I do want to give you the last word right before we're coming up on 4 o'clock, but I want to give you the opportunity to respond and add any closing comments for us.
Sure. Yeah, I think the reflection would be that, I'm most concerned about commercial use of private data. And I think that's where the profits are. That's where the lobbying is going to go. Research use, far less concerning, but could be a casualty depending on how we frame data privacy legislation. And so we would have to be very careful in how we structure and frame any sort of data privacy regulations or policy changes moving forward.
Awesome. Okay, well, that's a great place to end. Michael Sinha, thank you so much for being here, sharing your work, and engaging in a conversation with all of us. Thank you for everybody else who stuck it out for the full hour. I appreciate your being here. Brian, I'm going to officially call it to a